So the videos that are above relate to what's called the common law right of the employee to sue when he or she has been treated unfairly in the investigative process. There is also a firm obligation to investigate any allegation of workplace discrimination under the Human Rights Code and also under the Occupational Health and Safety Act, which promotes a safe work environment. Now, in both these statutes, there is this affirmative obligation to investigate. In the common law, the obligation to investigate will arise where there are serious allegations of misconduct. So these two statutes don't obviously require that underpinning. Any knowledge the employer has of any wrongdoing under the Human Rights Code or the Occupational Health and Safety Act must be investigated by the employer. And that applies whether or not a complaint is filed. There was one case recently in which in a unionized context, in which the victim of the alleged, which was then a sexual harassment issue, did not want to file a complaint, but the employer was nonetheless aware of it. When the case initially went to hearing, the first hearing before an arbitrator, which is the means under the collective agreement, determined that the persons who were fired improperly because the victim did not actually institute a complaint procedure. That decision was set aside by the appeal court and divisional court, as it's called, and the case was sent back for a new hearing. But basically the theme that comes from this is that the employer does not act based on the existence of a formal complaint. The employer must act based on its awareness of unsafe working conditions, whether that's human rights or occupational health and safety. Another point under human rights legislation is that although there had been divided decisions on this point, it appears now that the failure to investigate can lead to an independent remedy. That is, even if the underlying complaint fails, let's suppose there's a human rights allegation of sexual harassment or whatever it may be, and the employer does not conduct a proper investigation, the fact that the investigation was not conducted gives rise to an individual claim for damages, even if the sexual harassment is not proven. And in a recent decision under that section of the code determined by a judge in civil court, an award of $50,000 was made due to the failure of the employer to make a proper investigation. So it's a serious issue. And by the way, generally in human rights, if there is an entitlement, a remedy, another example is what's called a reprisal remedy. So a reprisal basically arises where the employer has taken adverse action against an individual because of a threatened complaint or an actual complaint. So let's suppose Harry has filed a complaint alleging he was terminated or treated adversely due to race, and the employer then, in fact, takes other action against him, such as termination if he wasn't first terminated. That's called a reprisal remedy, and that again stands independently of the underlying complaint. So even if Harry cannot prove that he was treated adversely due to race, if the employer acted unfairly, there's an individual claim for reprisal. So that's an important issue in human rights generally, not just the issue of the obligation to investigate.